Good afternoon, everyone. My name is John Cornwell, and I'm Plunkett Cooney's Director of Marketing and Business Development. It's my pleasure to serve as coordinator for today's webinar, which I'm happy to host on behalf of the firm's commercial litigation and cannabis industry groups. From our perspective, the cannabis industry remains a pretty rough and tumble world. It's constantly in flux as businesses form, regulation, enforcement ramps up, and communities continue to struggle with whether to even issue cannabis business licenses. The environment's ripe for pitfalls and dead ends that create tension among business owners, investors, suppliers, public officials, and others who impact the industry. That's why we're calling today's program Mad Money. We don't have time to tackle all the challenges impacting the cannabis industry, so we're focusing today on two big areas of concern, those being mitigating liability for shareholder disputes, or from shareholder disputes, and regulatory enforcement of notice requirements after changes in organizational structure. So joining me today are two of the firm's most experienced business attorneys, Patrick Lannon and Saulus Michelanis. Patrick is a partner in our and co-leader of our firm's commercial litigation practice group, and Saulus is founding member of our and co-leader of our cannabis industry group. Before we get started, I'd like to just take a few moments to provide you with some background about our law firm and today's presenters. For those of you who don't know, Plunkett Cooney is based in Southeast Michigan and is one of the Midwest's oldest and largest law firms with approximately 140 attorneys. We have 7 offices in Michigan, as well as 1 each in Chicago, Illinois, Indianapolis, Indiana, and Columbus, Ohio. Plunkett Cooney is one of the state's most experienced and accomplished law firms in the areas of business, finance, litigation, and recently cannabis law. The firm has secured some of the state's first cannabis business licenses, and our attorneys work daily to assist cannabis business industry clients with expanding their businesses and remaining compliant with the many state and federal regulatory requirements that are out there. Joining me today, as I mentioned, are Patrick Lannon and Saulus Michelanis. And let me start with a quick introduction about Patrick. He's a member of our Bloomfield Hills office, and he represents financial institutions, lenders, and banks in commercial lending actions in the areas of collections and real estate disputes, including loan workouts, foreclosures, real estate actions, and related commercial contract actions. He also represents other commercial entities in various contract-based commercial disputes, including cannabis businesses. Saulus, who also works in Plunkett Cooney's Bloomfield Hills office, maintains a busy practice in such areas as environmental law and energy law. Saulus is always on the cutting edge of the law, it seems, and including most recently the medical and recreational use of cannabis. He has been working with his cannabis industry clients for years now, helping them to obtain required business licenses and to remain compliant with state and local regulations. So now just a couple of housekeeping notes for today's program, and we'll get started. For the Q&A portion of our webinar, we're going to use our questions windows on your GoToWebinar navigation display. So if you can, just take a moment now to locate that window and feel free to enter any questions as they occur to you during the program. At the end of the presentation, we're going to try to answer as many questions as possible, but I always add one caveat, which is to please keep your questions a bit general if you can. Discussing specifics going on in your business is best done privately, as we're sure you will agree. So on that note, we're going to get going into our presentation, and I'll throw it over to Saulus, and we'll forge ahead in this interesting area of the law.
Good afternoon, everyone. Happy to be here. So with respect to today's topic, it's vital to understand what disclosures need to be made, who may be involved in the ownership and the operation of cannabis facilities. There are strict rules as to what must be disclosed to regulatory authorities, what things would disqualify certain people or entities from obtaining licenses. Further, applicants must meet baseline capitalization requirements to demonstrate that they have the capital to operate a particular cannabis business. As a result of all these requirements, businesses are formed to take advantage of the likelihood that individual members can meet the strict prerequisites for becoming pre-qualified and eventually receive a license. In many cases, individuals form entities because they can run the gauntlet of background checks and capitalization requirements, but may not have much else in common. They may not have even known each other until just before the corporation formation. These strict requirements can make for strange bedfellows, and one result may be future friction between members that develops, which in turn may lead to legal action between the members. Once that occurs, it's important to retain the best representation to protect members' interests and hopefully keep the entity operational and profitable. After the dust clears, there may be reporting requirements to the states and local governments if new members are added or old ones are removed from the licensed operation. New members may also need to receive their own pre-qualification before consummating the transformed entity. The Michigan Medical Marijuana Facilities Licensing Act, or MMFLA, governs the licensing of medical cannabis growers, processors, provisioning centers, which are commonly referred to as dispensaries, transporters, and safety labs. In order to even apply for an operating license, applicants must seek pre-qualification from the Department of Licensing and Regulatory Affairs, or also known as LARA. Pre-qualification is an arduous process where all relevant stakeholders are vetted to make sure that they meet the standards required to obtain the license by statute. Part of the pre-qualification process is the disclosure of individuals involved in the entity seeking pre-qualification. Who must be disclosed depends on the nature of the entity seeking the license. Disclosure requirements for a privately or publicly held corporation include all corporate officers or those with titles equivalent to officer, all directors, and all stakeholders holding a direct or indirect ownership of 10% or more, and all their spouses. Spouses are required to be disclosed to prevent applicants from using their spouses to avoid disclosure of possibly disqualifying information. For partnerships or limited liability partnerships, disclosure requirements include the names of all partners and, again, their spouses. Limited liability companies must disclose all members and managers with an ownership interest of 10% or more and their spouses. As with the medical licenses, adult use applicants must also disclose the name of relevant entities and members. Managerial employees are those who direct or control the operations of a cannabis facility. Anyone having greater than 10% ownership interest in the main entity must also disclose. Following along is with those applying for medical cannabis licenses, adult use entities or recreational entities must disclose name and addresses of those who have interests along with their spouses. Further, if the entity is a multi-level ownership enterprise, any one of them that has the right to receive 10% or more of gross or net profits must be disclosed. So, for the purposes of disclosure is to determine if any of the parties involved in the ownership, operation, or control of the licensed entity have passed that may disqualify them. As I noted earlier, often people who arrange entities seek individuals who can face the strict scrutiny that the laws require and get pre-qualified. A criminal history may disqualify an individual. Obviously, small minor matters will not disqualify otherwise qualified individuals, so don't worry if you have a lot of traffic tickets. But if one has a conviction of a felony or a controlled substance felony in the last 10 years, they cannot be licensed. Another disqualifying factor is if the applicant was convicted of a misdemeanor involving a controlled substance, theft, dishonesty, or fraud within the prior 5 years. So there are certain things that will keep people from being qualified. Other disqualifying factors include having an application for operation in another state denied, whether the applicant has any state or local tax delinquency. That's a big one. The applicant or spouse is a public official or holds an elective office or holds a license in another regulated activity, because certain licenses preclude ownership in certain other licenses per the statute. For example, if you have a license for a safety compliance facility, you cannot have an interest, any kind, in a processing facility. There are other examples. In considering an application, LARA can consider other potentially disqualifying conditions. They include providing false information, bankruptcy within the last 7 years, being a defendant in a business litigation, non-compliance with other regulatory requirements in Michigan or any other jurisdiction. These factors pertain to the integrity, moral character, and reputation, personal and business reputation, financial ability and experience, and responsibility or means to operate or maintain a cannabis facility. Obviously, these factors don't disqualify you from opening a 7-Eleven. It would disqualify you from opening a cannabis facility. There's so many potential pitfalls for any person looking to enter the medical or adult use cannabis markets. As a result, the universe of potential business parties can be very restricted. It's very important that when one enters a business relationship, that all those with whom you'll be working and investing are fully vetted. These are some of the questions one needs to ask. Oftentimes, we do our own criminal background checks before we even submit an application or even before developing corporations. And even if the individuals meet the strict requirements, there's always the question of compatibility and demeanor. In the beginning, when the common goal of passing qualification, obtaining local approval, and eventually getting a state license incentivizes people to pull in the same direction, everyone gets along fine. When the hard work of making the business profitable and sharing the fruits of one's efforts start, things can fall apart quickly and for a variety of reasons. Other conflicts arise, when some want to cash in and others want to continue. Exacerbating these tensions can be poorly worded agreements and corporate documents. When that occurs, you just might need a guy like Patrick Lanning.
Thanks, Hollis. That was a great presentation. I appreciate your time and all of the nuts and bolts you gave about qualification as an operating entity in the marijuana sector. I am looking forward to just walking through the audience a couple of the things I've noticed in litigating and preparing to litigate and potentially avoiding litigating partnership disputes in the marijuana industry. To that end, I've prepared a couple short slides that will give bullet points with things to consider when drafting an agreement to enter into this market or trying to get out of the market or trying to get out of a problem that you found yourself once you're in the market. I want to start off with giving you each about 6 points to consider with respect to your partnership agreements. For sake of this conversation, I assume that all of the compliance and license issues have been satisfied. But of course, what I've found in the last 3 years in litigating marijuana-based disputes of any kind is that there are other things in the traditional nature of law firm review that have derailed otherwise successful marijuana companies. First and foremost, I want to start out with the basic considerations of what leads to a partnership dispute. It's been our experience that clients who have otherwise successful businesses face a number of problems running a marijuana business just like he or she would any other business. For example, oftentimes two partners wish to grow a business, but their views of how to grow the business are not otherwise the same. One may wish to spend more on expansion. One may wish to spend more in other areas. What we've found has been successful historically is to include what we refer to as a pre-dispute mediation provision within a partnership agreement. A provision in this respect is something that reads in the nature of two partners otherwise disagreeing about any element of his or her business must, prior to litigation, engage in a multi-step or singular step mediation process. A provision like this is widely enforceable in Michigan and is strictly enforced in various court decisions across our state. Courts especially look forward to enforcing an agreement that provides two partners must sit down and voluntarily try to work out their differences prior to filing a lawsuit. This is both something that judges look forward to enforcing because it avoids otherwise cluttering their busy dockets, and also because businesses generally operate much more effectively when they're not distracted by the cost, expense, and otherwise dramatic occurrences in day-to-day partnership disputes. Next, we want to talk about access to books and records. Most likely, the fundamental and key dispute leading to business arguments between shareholders, partners, and members has to do with access to books and records. Both the Michigan Business Corporation Act and the Michigan Limited Liability Company Act give broad access to members and shareholders alike to, at reasonable hours, access all books and records of the company that pertain to the financial condition of the entity. Blocking or otherwise distracting from one's access to books and records can be viewed and often is sustained as an automatic violation of a member or shareholder's rights and duties. Considering and understanding this requirement at the time you form your partnership or at the time you enforce your partnership rights is a key consideration both in and out of the marijuana industry. Next, we want to talk about book valuation. In the event of a partnership dispute that arises or ends with a partnership buyout, book value is often used as the fundamental consideration for the value of a member or shareholder's interests. Our next topic is fiduciary duties. Fiduciary duties, to be brief, are the duties owed by an operating manager of an entity to his or her company and to look out for the best interests of the company as a reasonable person would under the circumstances. Authority to bind the company is our next topic. This is a very popular topic in the marijuana industry. What we've found in litigating these disputes for the last several years is that individuals operating in this industry are both those who just enjoy operating in the business and also those looking to maximize the return on their investments. As to the latter category of people, it's been our experience that agreements generally fail to address the rights and duties of officers, directors, and shareholders to otherwise bind the company and sell the company's data to prospective investors. Finally, we want to be clear about use. Use of marijuana as a substance is, of course, a regulated issue, as Sullis alluded to. However, the enforcement of the use of either recreational or medicinal marijuana is protected in both civil actions and criminal actions under the Michigan Medical Marijuana Act. The number one defense I'd like to mention is something to be aware of. It has to do with a 2019 Michigan Court of Appeals decision called Varela versus Spansky. In what will be a published decision that is less than a year old, the Michigan Court of Appeals refused to enforce a signed written agreement that provided for the production of certain marijuana products to be sold for medicinal purposes. What otherwise seemed to be a very straightforward agreement between certain investors and marijuana operators was not enforceable according to the Court of Appeals because the agreement on its face stated that the operators and producers intended to grow an amount and to distribute it for sale in excess of the 2.5 ounces authorized by the Michigan Medical Marijuana Act. I find this decision very interesting, and it has a great influence on all marijuana industries when certain entities experience partnership disputes of any kind. The key consideration I take from it is simply that to the extent investors or operators or any type of entity enter into an agreement for the production and sale of any marijuana product that is in excess of authorized recreational or medicinal limitations, courts in Michigan will refuse to enforce such agreements. Those agreements, the courts say, are illegal from the outset, and the courts will take no effort to effectuate the intent of the parties. What's especially interesting about the Varela decision, of course, is that the parties' agreement did not just pertain to the production of marijuana products. It also applied to ownership and use of the equipment that was to be used in the production. And as to that equipment as well, which has a valuable commercial nature, the court refused to enforce the parties' agreement as to ownership of the equipment because it was also rooted in what was otherwise an illegal agreement. So my sense in litigating these disputes is to use this case in your arsenal of tools and to think of it as something that parties, when contracting, want to be very clear in their written agreements, if they seek to enforce them, that all of their production, investment, and operational goals will be stated on the face of the agreement to be totally complicit with both medicinal and recreational laws of the state of Michigan. A next key defense to think about when forming your documents to operate in the sector or to otherwise enforce your instruments when operating in the sector is a decision called the State of Michigan versus McQueen. This is a mid-Michigan decision that was decided by the Michigan Supreme Court. Interestingly, an entrepreneur in that section of the state thought of a concept that we often see every day and think nothing of it. If you walk into a restaurant and you see certain wine lockers or cigar lockers, it is a common practice for certain patrons of restaurants to keep a locker with his or her choice of beverage or other smoking products. In this particular case, a company formed an operating store that included marijuana product lockers. The store took a fee to rent the lockers to patrons, and patrons had the ability to conduct patron-to-patron sales of their marijuana products. The store did require all of its patrons to be card-carrying medicinal marijuana users or otherwise be within the recreational limitations of Michigan's law. However, the state of Michigan sued the entity, claiming that its operation was a public nuisance, that the ability of certain patrons to sell to one another is not consistent with Michigan's medical marijuana laws, that in the medicinal context, patient-to-patient sales do not fit within the use prescriptions of Michigan's Medicinal Marijuana Act, which only authorizes sales from a caretaker or otherwise statutorily authorized seller to a statutorily authorized user. Likewise, this consideration would be applicable in the recreational context, where it would be, unless a true gift, prohibited conduct for one user to buy or sell to another user an otherwise legal product. In the State versus McQueen decision, the Michigan Supreme Court sustained the local municipality's charges of a nuisance and therefore prohibited further commercial conduct of that business. This decision is highly consistent with the decision reached in Varela versus Spansky. And my point is simply this: if you wish to operate in the marijuana sector, if you wish to take on debt or equity, or otherwise behave in a commercial manner that is to enrich the profits of the company, it is both critical on its face and in practice to otherwise follow the strict considerations so as referred to within both the recreational and medicinal statutes. Next, I want to talk about some procedural pitfalls that we've seen in litigating shareholder disputes and partner disputes among companies operating in the sector. Something to consider right at the outset are how to avoid these disputes. And that first and foremost ground that we found successful is the use of an arbitration clause. An arbitration clause is something that should be written in a way that if it's the intent of the parties to avoid costly and expensive and time-consuming litigation, would direct the parties into an arbitration forum, which while also can be expensive, is something that should expedite a resolution of the parties. We will talk again about arbitration in just a moment. I also want to mention the procedural pitfall of the statute of limitations. Michigan has a statute of limitations that applies to any type of action one member or shareholder brings to try to redress his or her perceived wrongs under the LLC or Business Corporation Act. The ability to prolong or shorten the limitations period is well founded in the law and is something that is often not addressed in partnership agreements. It is a key area to consider both in litigating a partnership dispute, planning to avoid litigating a partnership dispute, and otherwise considering what the parties intend to do. As I mentioned earlier, keeping open access to books and records of an entity is perhaps the most often grounds for bringing a shareholder or partner case. Updated books and records is a critical thing since it exists as a fundamental tenet of partnership law that any shareholder or member has access to open books and records. It is my experience that keeping a provision in your partnership formational documents, acknowledging that right and setting exact time periods and access locations to so review that information enhances both a company's and the shareholder's ability to avoid otherwise costly disputes about where and how to access the information, how the information will be populated, and when and how someone should take some responsive action if the information either A, is not accessed or reveals otherwise troubling conduct. The final procedural pitfall I want to keep everyone aware of is a choice of law provision. In Michigan, our choice of law, of course, would generally default to the law of the state of Michigan unless otherwise selected by the parties. Certainly, parties can select application of the law of a form outside of Michigan, but that would be a potentially troublesome proposition in today's climate, since not all states have uniform marijuana use, production, transportation, and growing laws. Further, it is critical to recognize as a procedural pitfall that the marijuana is still scheduled as a federal drug, and therefore resorting to federal courts, which include bankruptcy courts, is probably not an option for anyone operating in the marijuana sector. This can be applicable to your business in a number of ways. First and foremost, getting into business with a vendor or customer who is subject to a chance of reaching an insolvent event and otherwise declaring bankruptcy may eliminate your right or ability in a bankrupt scenario from recovering money otherwise owed to you. Likewise, none of the bankruptcy protections may be available to a company whose primary business purpose is any type of service or sales based in marijuana products. Because of that, and because of the inability to seek recourse in the federal system, we suggest being very specific about the application of a certain choice of law in your partnership documents. In the next slide, I'm going to mention bookkeeping. Bookkeeping is a critical thing for a variety of reasons when operating a business, specifically in reference to avoiding or otherwise resolving a partnership dispute. It is not simply that access to books of shareholders and members is critical. It's also very critical to reflect a variety of other corporate activities to demonstrate proper observance of corporate formalities, which otherwise avoid or expedite successful resolution of a corporate dispute. While Michigan's case law developed in this sector is somewhat limited given the enactment only very recently of the Michigan Medicinal Marijuana Act, the law in Michigan's partnership dispute arena is well developed to a certain degree in other industries. And what we can take from those industries in applying them to the marijuana industry is that oftentimes companies do not observe all corporate formalities when the company is involved in more than one specific industry. For example, one of the most critical ways that companies have a tendency to find themselves in a shareholder or partner dispute is by the concept of self-dealing. Self-dealing simply relates to a scenario where an officer, director, or manager will be operating both on a day-to-day basis when wearing his or her manager hat and also operating while wearing his or her personal or other hat that has to do with a business purpose. The laws in Michigan, of course, are well developed to protect the interests of shareholders and members. To have officers, directors, and managers operate businesses in a way that a regularly prudent person would under like circumstances. When engaging in any type of self-dealing, even if it is authorized, it's critical that the books and records of the company reflect certain values that an officer, member, or manager would want to be clear on the face of the company's documents. For example, if a company wishes to operate and, in one sense, sell marijuana products both to customers and to other authorized end users, it is feasible that that is a recognized and legal transaction. However, if the authorization is limited with respect to who is going to get the proceeds from such sales, the books and records should clearly reveal, both in minutes and corporate resolutions, who and when the company has authorized to undertake those sales. Likewise, books and records are also critical to ensuring that the company properly spends its money on resources that benefit the company and not certain officers, managers, or directors individually. This is often another area in which corporate disputes arise and has to do with how to spend company money and whether company money should be spent for any specific business purpose or a different business purpose or on an employee or officer or member directly. Very briefly, I just wanted to reiterate that arbitration is a key consideration in your partnership agreement from the outset. It's also, of course, something that can be selected by the parties after a partnership agreement is signed. Arbitration is a faster way, generally speaking, to the end of a corporate dispute. However, it is also an expensive proposition. It's our experience that arbitration is an effective and enforceable grounds to avoid a costly and prolonged court dispute. However, selection of a great arbitrator is a key consideration, as is the timeline and cost limitations of what the parties agree in arbitration should include. Finally, something to consider is that arbitration gives great power to the arbitrator to make decisions that will likely be unreviewable by any type of appeal process. I wanted to leave everyone with an understanding of the bright line of arbitration as an enforcement mechanism. And with respect to that, it should be known that what scope of matters can or will be sent to arbitration is something that must be decided by the judge and not by an arbitrator, unless two parties agree in an arbitration agreement that the issues or whatever issue is in question shall be decided by an arbitrator. Next, I want to talk very briefly about something that comes up all the time in business disputes, and those are called book valuations and normalized adjustments. A normalized adjustment, in layman's terms, has to do with accounting changes that a company's accountant or someone evaluating a company's financial condition will make to otherwise demonstrate what the true numbers of the company are and what the values, both assets and liabilities, should be shown on a company's balance sheet. In the case of a closely held corporation, oftentimes there is a lack of marketability to sell a shareholder or member's interests. There are also otherwise financial statements and financial expenditures and savings that are useful tools when running a closely held corporation. Or alternatively, there may be certain operational reserve costs or capital expenditures that a closely held corporation does not make, which you might otherwise see in the case of a publicly traded company. To that end, when determining ultimate book valuation of a shareholder or member's interests, it is important to consider normalized adjustments that should be made to a company's books and records into determining at what exact amount of money someone should or should not be forced to purchase or sell his or her interest, or to determine what conditions and contingencies should otherwise go along with someone's decision or ultimate agreement to sell or purchase a membership or corporate interest. Keeping a clear understanding of normalized adjustments, the process that a company or a partner should go through to determine what those are, and how the price will be computed, in our experience, are key things to consider in advance of entering into a partnership agreement to avoid costly litigation. Or if you find yourself in such a dispute, you get out in front of those issues early so you determine the parameters of what type of financial accommodation or sacrifice someone is willing to make. One of the last issues I want to talk about is fiduciary duty. Fiduciary duty law in Michigan, to be generous, is to some degree murky. Generally speaking, fiduciary duties in Michigan are similar between corporations and limited liability companies. It is the case that generally speaking, and with very seldom exceptions, fiduciary duties are owed by officers and directors and managers of corporations and companies respectively in favor of the company. In other words, a member of a company or a shareholder of a company has no direct claim against a manager or an officer or a director for actions taken that have an impact on the member or shareholder's status. That is because, generally speaking, a manager or an officer or director owes the fiduciary duty to the company itself. It is the company, the entity, the corporation for whom the manager, director, or officer must look out for on a day-to-day basis. It is that entity for whom the manager, officer, or director has a fiduciary obligation. It is often misperceived thought that someone who is a member or a shareholder of an entity operating in any space has a direct claim against someone who runs the company. While, of course, under certain circumstances and depending on the agreement of the parties, that can be changed, it's an important perception to recognize what types of duties will be benefiting you as an investor and what types of duties will not benefit you as an investor when you take a position in a marijuana entity. Finally, we want to talk about, just very briefly, the specific limitations of the Medicinal and Recreational Acts. Because of the Varela opinion that I mentioned earlier today, and because of the state action on public nuisance that I mentioned earlier today, we want to be clear that there was some very troubling language in the opinions for anyone who intends, considers, or inadvertently operates in the marijuana industry outside the strict limitations of the recreational and medicinal statutes. In the Varela opinion, and by the plain holding of the State versus McQueen decision, it's very clear that law enforcement and their constituent parts throughout the state have, will, and often do prosecute criminal matters for those operators in a commercial context who don't follow the rigid contours of the statutes. We're happy to supply, of course, the legal citations to those decisions, and even a cursory review of them will demonstrate that it is fraught with error to seek to chase some sort of profitable return by not observing all of the strict usage limitations within the medicinal and recreational statutes. And with that, we'll take any questions. And
we have a couple wrap-ups here. Yeah, I've got a couple more slides to stall us. Please be aware that our audio-visual problems have no relation to anyone's use of any regulated substances. This is all technical. And we try to do our best to push through this. So we appreciate your patience very much. So, so after the dust is settled and the dispute's over in whatever form, what do you do next? Assuming that there is an entity, a restructured entity that exists at the end of the day, perhaps with different people involved and different managers and the like, there are several reporting obligations that you need to be aware of. A change in ownership requires the submission of a form to the Michigan Marijuana Regulatory Agency, or the MRA. The submittals will also require updated disclosures. Familiar with the application process, you should be very, pre-qualification process, you should be very familiar with disclosures. But disclosures are forms and part of the pre-qualification process, and they must also be updated as things change. Whether or not you have a shareholder dispute that's changing things. Even voluntary change is required to be disclosed. So under Disclosure 2A Part 1, that's the disclosure of added individuals and added entities. So if the reorganization adds new members to the mix, those names need to be disclosed. This also includes spouses. Disclosure 2A Part 2 identifies any additional ownership interests. So if the restructuring results in the acquisition of any other ownership interest, that must be disclosed. Disclosure 2E requires the disclosure of other interests and added entities or individuals. That would include officers, directors, or managerial employees. New stockholders holding more than 10% will need to be disclosed. If there are any alterations to any of the previously disclosed documents to the MRA or LARA, like bylaws, operating agreements, organizational charts, resolutions, documents related to the purchase or transfer of interest, and proof of payment, all those may need to be disclosed. If the changes affect capitalization requirements under the statute, like if one exiting member was the basis for demonstrating adequate capitalization, new CPA-attested financial statements, money lender forms or promissory notes or credit documents may also need to be submitted. You should also check with applicable local ordinances. Many of those ordinances require prior notice and approval of any conveyance in order to maintain your licenses. These notices should be provided as soon as possible. While this may be difficult during litigation or dispute resolution, settlement of any matter must bake into it the timeline for notice and approval where necessary. So what happens if you don't update your information? Well, the license you have is a revocable privilege, not a property right. Under the MMFLA, a transfer or any other conveyance of a license without prior approval is subject to suspension or revocation of the license. Other sanctions are also available, especially if the facility remains in operation after transfer with no prior notice. What kind of problems you could have? Well, you could face civil fines up to $5,000 for individuals. Also, the licensed entity could face a $10,000 penalty or an amount equal to the daily gross receipts, whichever is greater, against the licensee for each individual violations. More violations, more problems. Continued operation after revocation and suspension carries with it even more severe penalties. A first violation is a misdemeanor with a fine between $10,000 and $25,000 or imprisonment of not more than 93 days. A second violation is a felony with the same range of potential penalties and up to 4 years in prison. Revocation by the agency will be done consistently with the Administrative Procedures Act, requiring notice and a hearing. Any suspension could remain in place until the conclusion of an administrative hearing. That means your business is not operating, you're not making money, shareholders will be sad. Sometimes expediency and convenience require cannabis businesses to partner up in order to obtain capital, avoid disqualifying conditions, take advantage of synergies between people and entities, or use local connections to obtain local approvals. But once the immediacy of obtaining state and local approval dissipates, disagreements may arise due to badly drafted corporate documents or agreements, personality issues, good faith disagreements about the evolution of a business, desires on the part of some individuals to cash out, etc. Those may result in disputes that need to be resolved through litigation or dispute resolution. When that happens, you may need someone like Patrick to see you through. Once on the other side, however, don't forget that there are reporting responsibilities at the state and possibly local level, and failure to comply may mean the end of a business entity, fines, and jail time. Or as Kevin Kline said in A Fish Called Wanda, man without a plan is no man, Nietzsche. That also applies for women.
Now's the time to enter any questions you may have into our questions window. I do see there is one here that we're going to take a look at. And the first one is, would you put a fiduciary duty requirement in the operating agreement?
This is Patrick. I'll take that question. Thanks, John. I think that is certainly a strong consideration. As often is the case, the answer really turns on the personality of those forming the business. I think it also is something to consider with respect to what in scenarios someone would wish a fiduciary duty to exist. And so my answer to the question is, generally speaking, yes, I would insert specific provisions addressing these instances where a fiduciary duty does and does not exist.
Great, thank you. There are a couple more here, so let's kind of keep going. The second question is, are cannabis business disputes limited only to state courts?
Yes, as we spoke of earlier, as a scheduled drug, federal courts have refused, and there is a pretty significant body of case law with scant exception that we can find, where disputes involving marijuana entities or marijuana usages can be litigated in a civil context in the federal court system.
That includes bankruptcy too. Basically, you can't take advantage of any federal system or program. The only obligation you have is to pay your taxes.
It's funny you mentioned bankruptcy. There's a question here that says, what if someone you're involved with files for bankruptcy?
This is not a well-developed area of the law, but if someone you're involved with files bankruptcy, it would be my anticipation that enforcement of your rights against the bankrupt party would be questionable in the bankruptcy itself, and that the person may otherwise qualify for bankruptcy protection potentially and be able to avoid having to otherwise deal with a debt having to do with the marijuana industry.
But there may be state equivalences that may apply.
Okay, there's just a couple more here. Again, if you want to ask a question, type it into the questions window on your GoToWebinar desktop. The next question is, what can be done to try to limit the chances of a shareholder dispute?
Drafting really good agreements going into it, vetting your business partners and entities to make sure that there are no little hidden landmines, and make sure that you guys are compatible. Expediency can put people together that aren't necessarily compatible. It may seem like a good idea at the time, but looking back, maybe take a vacation together. No, I'm just kidding. Just figure out whether what you have is something that you need to get done to get your business open, or whether you guys can actually move forward hand in glove to see this thing through.
Great. There looks like there's one final question, and again, last call for questions, so type them in. Otherwise, this will be our final question. Why should we be more concerned about disputes involving cannabis businesses than any other?
Sure, it's a good question. And the reason is because it's a more highly regulated industry. Cannabis has additional risks and additional considerations as an operating business entity, and that simply, of course, increases the number of opportunities where a dispute could arise. Perfect.
All right, well, that looks like that is the end of our questions, so we'll go ahead and keep moving through and wrap things up. So we're going to, at the conclusion of the program, we're going to send you a little pop-up that includes a link to a survey. We hope you take a second to fill that out for us and take it easy on us on the tech question. We definitely deserve it, but please respond to that, and any topics you may suggest in that quick survey, we do take those into consideration for future events. So share your ideas on topics. We really like that. A couple of promotional things before we leave. This program it has been recorded, and we're going to have that available later today, hopefully, if our website is not giving us problems like the rest of the tech. But we'll have that recording, so if you want to share that with others in your organization or your sphere, please pass that along to them. It'll be at the bottom of the event page, so check that out. We also have 2 blogs that we're promoting today because we have our speakers from 2 different groups today. We have our Don't Bet the Business blog, which our commercial lit group really takes care of, and they post a lot of great information generally about business and risk management, so check that out. And we also have our Cannabis Law blog. Both of our blogs, you can throw your email address into the email window there to subscribe, and anytime there's any updates there, you will be made aware of those, so you can check those out as well. So we appreciate that. And as always, hopefully you will like and share that content. So on behalf of Patrick and Sauls, we really appreciate you hanging in there with us today, and look for future events from our groups, and hopefully we'll see you down the road, and have a great rest of the day.